Lordship, I like to make a mention for a unlisted motion today.
What?
Lordship, this matter relates to sending of the petitioner to training.
Hmm.
He has been promoted as the sub-inspector of an armed branch on 30th of January. Thereafter, on 7th of February, he has been transferred from Guwahati to Dhemaji and again transferred back to Guwahati. In the meantime, the police headquarters has proposed a list of the persons to be sent out training, the promoted persons. Because he was nowhere, he has been left out, Lordship, when the training starts today. So, like, Lordship.
Once it's ready, you.
Yes.
I beg to mention for one IA for listing mail, orders matter.
Okay, 21st.
Yeah, please, Lordship. I beg to mention for a listing of a writ petition, Lordship. It was 2021 meter, Lordship, last listed on 2023
Hmm.
in the year 2020.
Okay. 26.
Oh, bless, Lordship.
May I please, your Lordship,
Oh.
I beg to mention for listing my letter, similar matter was fixed on Friday month. So this matter come along this matter much.
May I please, your Lordship? I am praying for listing of writ petition, my lord, in the hearing column, my lord.
Hearing column.
My lord.
When?
My lord, any date, my lord,
28. Oh, no. 27th.
27. Bless.
May I please, your Lordship, also I beg to mention for listing of a contempt case on 22nd in orders.
Okay.
Much obliged.
Maybe Lordship, I beg to mention for item writ petition mail. Matter pertains to permission, my lord.
You want it listed?
Yes, my lord.
Okay. 28.
Yes, my lord.
May I please, your Lordship? Lordship, I beg to mention item number 12 to 19.
12 to.
19.
What is it?
It's a serious matter, your Lordship.
Hmm.
I have taken consent of all the other counsel. Let the matter be taken up some other day, your Lordship.
You're mentioning on behalf of
Petitioner.
You are in 13th.
which council?
I'm in item number 14.
Ken Chowdhury.
Ken Chaudhary.
Okay. On request made on behalf of Mr. Ken Chowdhury, the senior counsel appearing for the petitioners in WBC 8082 of 2022. When do you want?
Any convenient date after 22nd of February, your Lordship.
In that case, my lord, it has to be March. My lord.
March.
Towards the end of February, I am totally tied up.
Okay.
In that case, very
12th.
19th, are you? 19th.
Hearing date হলে ভালো।
19th is a
19th is
Tuesday.
Tuesday.
তো অলপ আগত কৰিলে around 7th of March.
Are you okay?
7th.
7 March.
Lord, I am for the petitioner in item 12, 15, 16, 17, 18 and 19.
7th month.
7th of March.
March.
CPO place,
Right.
your Lordship.
Item 1 for admission.
Pleadings have been exchanged, my lord.
Hmm.
Let me issue rule and hear the matter.
You on the 3rd? Yes, you are for petitioner?
He is
Yes,
the
sir.
petitioner, my lord.
You are the petitioner person?
Yes, Lordship. Yes, Lordship.
Okay. Heard Mr.
Avinash Gora.
Abhinash Voral and it's petitioner in person.
Lordship, Lordship, on 7th of February, I have received an affidavit from respondent number 4, 5 and 6.
Hmm.
So till yesterday, I submitted my affidavit.
Hmm.
So grateful if 1 week time may be granted for preparing my.
You want to file a reply or you have filed your
He has
reply?
filed his reply.
reply. Yesterday, I had completed Lordship.
Oh,
So if
Yesterday, he has filed a reply, my lord. I don't think whether it is on record or not.
yes.
So
it
the
is not-
pleadings have been exchanged by the party. Lordship may issue rule and hear the matter, my lord. Because it's a departmental proceeding, lordship sees the pleadings have gone around 2000 pages, my lord.
Then we'll hear it.
Lordship will hear the matter.
You want some time for preparation. is it?
Yes, yes,
That is what.
That will give you. Okay, heard so and so, petition in person. Also heard Mr.
And Decca for 1 and 2 months. 2 and 3, sorry.
Learning Council for the respondents, 2
Two
and
and
3,
three.
and Mr.
NK Sharma Lord.
N.K. Sharma for respond number
4, 5 and 6.
4, 5, and 6. Stop. Pleadings are complete. Issue rule. As all parties are represented, no formal steps are required. List the matter for hearing. In usual course or you want a date?
Kindly
Before
kindly
this-
provide a pic, kindly provide a pic
March?
Yes.
as much as possible, as early as possible, because I have, my mother is suffering from some medical problem. Okay,
Okay, 14th March.
14.
Item 2 and 3.
Please, your lordship, in this matter, in item number 3, lordship, Mr. T.J. Mahanta appears for private respondent, lordship. He is on legs in another court, lordship. Kindly pass over the matter for the time being, lordship.
Timing.
My lord, in the meantime, my lord, I think he can come. Let me start, my lord. I'm for the petitioner. This has been pending for. Let her be there. Let her be there.
Readings are complete. Matter is ready for hearing. Will be taken up for hearing, Lord. Maybe it is-
No, it has come for, my lord, disposal at the admission stage. My lord, order is also there. So nothing, let him come. I'll start. In the meantime, I'll place the facts.
No, but if pleadings are complete, we'll issue rule and fix a date.
No,
for
my lord,
hearing.
there is an order, my lord, specific order for early disposal.
That's why.
My lord, matter relates, my lord.
We can fix it on the hearing day.
My lord, today is a hearing day.
No, today is a hearing day.
At the admission stage itself, man,
Oh,
that
you
is the
want
order.
it disposed in the
Yes,
admission
man. Yes,
stage.
man. My lord, very short matter, man.
Okay.
Let me place the facts. In the meantime, Mr. Mohan can come.
Lordship.
And my learned senior friend is there already. He is the main respondent, my lord. Actually, I don't have against my lord.
Actual benefit goes to respondent, private respondent, Lord.
He has to defend in any case first, man.
Let us see
Yes, madam.
who are the respondents.
My lord, the respondents list, my lord, is
Union of India,
yes, my lord.
who appears? IIT,
Myself,
My
you
senior
are
friend.
appearing. You are appearing for 2 and 3
Lordship.
and 4.
Yes, Lord.
Then 5, Departmental Promotion Committee.
2 matters. 2 matters.
2 to 6, Lordship, I am appearing.
7, my lord, Mr.
No,
Mohan.
no, I'm on item 2.
In item 2, Lordship, we are appearing for 2 to 5.
2 to 5.
Yes. I
IIT.
No.
Both of you together.
Yeah. She is assisting me, Lord.
Okay. Oh, but where's the union?
Mr. Bhattacharjee used to appear. P. Bhattacharjee.
The P percentage probably.
One. In item 3, union is also there. IIT,
Same connected with the same issue, Lord.
IIT, Board of Governors,
Mainly, my lord, this is the IIT.
2
So,
to 6.
yes, ma'am. Yes, ma'am.
And Mahanda is for 7.
Yes, ma'am.
But the union,
Union.
Union of India will
Mr.
come, my lord.
Bhattacharjee appears.
Main respondents, my lord, will be my lord, my learned senior friend.
Union is a party.
His party's name is shown, my
He
lord.
should
He
be
appears.
come. He should come.
He will come, my lord. Let me place the facts.
Mr. Bhattacharjee,
Let us start.
no, supposing if you place your facts and
Yes.
then in the meantime the union does not come,
He has to
Shoulder
come, my
matter.
lord. His name is shown, my lord. The matter is fixed for disposal at the admission stage.
who appears for union? Catch hold of one of the union CGC.
the P Bhattacharjee normally appears for.
Who?
P.
Mr.
Bhattacharjee,
P.
Mr.
Bhattacharjee.
P. Bhattacharjee normally appears in these matters.
There are other council, but Mr. P.
P.
Bhattacharjee used to
Lordship.
appear.
If the union comes, there's no problem. Once Mahanda will come by.
Yes, yes.
You can send your junior, one of you, catch hold of the union.
I think somebody has already.
Lord, maybe fix on a hearing date, Lord. Any hearing date.
My lord,
Or
let it
hearing.
not, my lord, there are enough adjournments, my lord. I am suffering.
Not
Not matter is
at all,
stopped.
it's-
Pleadings complete, my lord. Why should we adjourn it every day? It's come on there is a specific order, my lord. It is always coming this prayer from the other side.
No, it's Lord will kindly look up the records. It's for petitioner's side.
My lord,
Last 2, 3.
on the last occasion, my lord, my personal
Last
difficulty was
occasion,
there. Other than that, your lordship will kindly send.
Pray for John, my lord. If that doesn't benefit.
They're always, my lord,
No, not always. How
seeking
many
time,
days?
my lord.
Show it.
I don't know, my lord, why they are, my lord, not trying to come up.
Yeah, appearing, yeah, Gary.
Yes, my attendance.
2 and 3. 2 and 3. Yeah, what I appear going to the 2 and 3. Formal.
Yeah, appearing. Okay.
Well, let me start. Madam, your lordship will see, this is a matter, madam, where the petitioner, the post involved is the post of assistant registrar in the Kadaz. Assistant registrar, madam. Now, the post of assistant registrar is filled up 2 ways, madam. One through internal promotion from the serving candidates, and the other through direct recruitment. Previously, madam, the division was like 75%, 25%, 75% from direct recruitment and 25% from internal candidates. Man. In due course, my lord, that was changed to 50%, 50%, my lord, following a directive from the central government, my lord. So that promotional quota is also 50%, and the direct recruitment quota is also 50%. Man. And the documents I'll place those.
So presently 50-50.
50-50. Presently 50.
Earlier it was 75-25.
Senate 25. Because of 50-50, one post had arisen, come to the side of the internal promotion, man. So that is the post which is in dispute, man. Where, my lord, the petitioner has applied, and the client of my learned friend Mahanta had also applied, man. And he has been, his selection has been approved, and he has been, my lord, appointed during the pendency of the first petition itself, my lord. That is why the second petition has come, my lord, bringing in the minutes, my lord, challenging the minutes. That is the fact, my lord. Your lordship will kindly appreciate. There is a rule, my lord, which is for, my lord, governing all these, my lord. That is, these are the called Department of Personnel and Training rules of the central government, my lord, which are governing the.
Where's the rule?
My lord, one copy should be there in the record, but I have another copy I can place, my lord.
1 minute.
I have also quoted it. Well, I'll place it. I'll give it. If your lordship comes to page 10 of the writ petition 3937. Second writ petition, madam. That is the comprehensive writ petition.
So you're arguing on the second writ
Second writ
petition?
petition, yes, it is a comprehensive.
So on the second writ petition?
Yes, ma'am.
3937.
3937, exactly, madam. Page 10, para 7, madam.
Mm.
The para starts at 7, my lord. The rule is quoted at page 11, madam. Next page, madam. Your lordship will see 449 cases of occurrence of additional vacancies in a year. They have a, my lord, vacancy year. They call it vacancy year, which ends at the 31st of December, on 31st of December of the year. So that is the vacancy year from the 1st of January to, that also I will place, my lord. The rule is like this, my lord. If a selection is, my lord, conducted during the time in any place in a year, my lord, they make a panel list extra, my lord, apart from the vacancies, the list for the, it's a wait list kind of a thing, man. So if another vacancy arises during the period of that vacancy year, not beyond it, my lord, so before 31st of December, so they don't go for another selection, man. From the wait list, they bring up the candidate and appointment. That is the rule, my lord. I'll just read it out. 4.4.9, my lord. It starts like this, where a DPC has already been held, page 11, my lord, in a year, and further vacancies arise during the same year due to death, resignation, voluntary retirement, etc., or because the vacancies are not intimated to the DPC due to error or omission on the part of the department concerned, the following procedure should be followed. D, my lord. I have skipped, my lord, A, B, C, which are not relevant, but the officers who have already been empaneled or placed in the extended panel but could not be promoted due to these vacancies not actually becoming available, did not be reassessed by the supplementary DPC as assessment metrics remain the same. They may be appointed against the additional vacancies of the same vacancy year as per recommendation of the earlier DPC. In such situation, number of vacancies and suppleants shall be accordingly adjusted. So the rule is clear. If a selection is already made and some people have been appointed to the advertised vacancies, and then there is a panel made, my lord, wait list, so that list remains. Supposing there is another vacancy arising within that vacancy, it has to be within that vacancy. Otherwise, they can go for press advertisement. In that case, my lord, they will bring the top, the candidate at the top of the wait list for appointment, my lord. That is the rule, my lord. And that is the, my lord, issue that your lordship has to decide, my lord. Now here, the petitioner has applied following, my lord, a notice of 5/1/22 for the post of assistant registrarman.
Yeah.
Your lordship can find that at Annexure 1, page 27. There is no issue relating to qualification or anything, my lord. Those are not disputed. Your lordship will see, my lord, 5/1/22 circular. It invites online application forms from eligible internal candidates for the following posts: assistant register. That is relevant, my lord. The qualification, eligibility criteria and mode of selection. Here, the petitioner qualifies. So that is also not an issue.
Assistant register,
Is post is assistant register.
4 posts,
Yes, my lord, 1 post.
4.
4 posts, my lord. Yes, initially 4 posts. Yes, this advertisement 4 posts. Correct.
And criteria is with 5 bases. Yes.
I am a senior superintendent, my lord. So I qualify to apply for assistant register with the required experience. Now your lordship will kindly come to Annexure 2, my lord. Page 29. This is the approval of the recommendation of the selection committee for the said post. Following advertisement of 5/22. Your lordship will see the 17 internal candidates name have been given at page 29, 1 to 17, my lord. My name is at serial 17, the petitioner.
And the private respondent.
Your lordship, private respondent's name can also be noted, my lord, at serial 8.
Is respondent number?
Is 7, response 7. Page 29.
Yeah.
Then page 30, my lord. The board was requested to approve the recommendation of the selection committee. The recommendation of the committee was opened before the BOG and that is Board of Governors, my lord, of the institution, IIT Guwahati. And the names were read aloud. The board was requested to consider and approve the selection committee report that recommend the following 4 candidates for the post assistant register unreserved via DPC meeting held on 18/2/2022. Your lordship will note the names given: Jeevan Chandra Boron, Nibha Devi, Rituparna Sharma, Jiten Soma. So these 4 were selected. And below that, Your Lordship will note the committee also recommended the following panel valid for 1 year. It is already mentioned there. This panel is valid for, so that is a live issue, my lord, at the time. My lord. It was, this list was live. Your Lordship will note the petitioner's name at the top. At serial 5, petitioner's name at the top of the wait list. Resolved, then, my lord, resolved to approve the recommendation of the Departmental Promotional Committee below that. Meeting for selection of 4 candidates and the panel mentioned above for the post of assistant minister held on 18 to 20. So that was approved, my lord. Now, your lordship will kindly see at Annexure 3, my lord, which selection I have impugned, my lord. Your lordship at page 31, serial number 1. This is the second selection that was notified on 12/12/2022. A singular post, my lord, of assistant registrar. And the
This is impugned.
this is impugned. Impugned, I'll come to that later, my lord. The petitioner applied against this. He was in the top of the wait list, but that was not made known to him, man. This is an admitted fact, man. That I was at the top of the wait list, that was not made known to him. And this occurrence 12/12/2002, your lordship will also note, this is within that vacancy year, within 31st of December of 2022. So I applied, my lord. Your lordship, next page, my lord, eligibility given, my lord. So there was no issue. I was, my lord, called for it, my lord. Everything was fine. Then, my lord, the rule, my lord, I have annexed. Annexure 4, page 35. The rule that I had just referred to, my lord, 449, page 37. I will come to that later, my lord. Now, what has happened, my lord? Now, while the second selection was going on, my lord, it came to the knowledge of the petitioner that
This is not a rule, it's a guideline.
a guideline, exactly, ma'am, guideline. But that is the service guideline that is governing the affairs of the respondent organization. Now, my lord, at Annexure 5, my lord, your lordship will kindly see. This is a representation from the petitioner to the registrar. What he writes, appeal to reconsider the panel, page 38. Approved by the BOG's 110th meeting held on 31/3/2022 for the post of assistant and to cancel the internal advertisement for DPC dated 12/12/23 by memo number so and cancel the DPC held on date 11/5/23. This is dated 24/5. This is the point of time when it came to his knowledge that his name was already shortlisted in the wait list of the earlier selection. He didn't know. That is why he had applied in the subsequent, my lord, circular advertisement, subsequent notice. Because his case is that since he is already at the top of the wait list and the next post having arisen within that vacancy period, vacancy year. So therefore, they shouldn't have gone for the subsequent advertisement, which is not allowed by those guidelines. Instead, my lord, he should have been picked up from the wait list and he should have been. That is the case, man. And since I didn't know, why I didn't know, my lord? Because they kept it confidential. I'll just place it, man. And they didn't upload it in the website of the organization, man. That also I have annexed, man, papers. But this representative, my lord. So my point of knowledge is, my lord, 24/5/2023, my lord, about my selection in that wait list. Then he prayed that I hereby apply to consider me to appoint in the said vacancy as being number 1 of the panel under hold, which is still in force till 17/2/2023, because your lordship, that validity period was given of 1 year. So he said so. The release of the DPC advertisement number so and so therefore has no legal standing, and for that reason to cancel, for which I was so and so. My lord, then it was redirected. He had to file a different representation through proper channel, my lord. They insisted that it should go to the director of officiating. So same prayer, my lord, he made at page 39. Then the director forwards it to the register IC man for necessary action, etc. Now, along with his representation, I had also given some annexes. Your lordship will find at page 40 to show that similar promotions have been given, my lord, to the post of senior superintendent. In the page 40 and 41, my lord. Your lordship, 40, my lord, the candidate at serial 15, my lord, from panel, waitlist panel, my lord. Then next 16 in the next page, 17, 18. These were all from waitlist panel. So that practice was continued. Only, my lord, difference is, my lord, made in respect of the petitioner. It is not that they totally discontinued with this. They continued it, my lord. Same selection, different postman. Again at page 42 also, my lord, serial 24, 25, all from panel, my lord, they appointed from waitlist panel in subsequent vacancies during the same vacancy year. Page 44, my lord, serial 27, 28, Nilut Paul Deka, Bornali Deka Gogoi, etc. Now, since I, my lord, submitted the second representation, my lord, with the same prayer that I ought to have been appointed from the waitlist, my lord, instead of going for the subsequent advertisement. Then they replied to me by page 48 letter, my lord, dated 9/6/2023, Annexure 7.
Yes.
Response to your appeal to the officiating director. In response to your letter dated 31/5/2023 addressed to the director officiating on the subject cited above, the undersigned was directed to inform you the following. Your appeal is under consideration at the office of the registrar. If any agency, citing agency, you should have approached the registrar in search first before writing to the officiating. Why they write this, we do not know, because your lordship has seen, my lord, I had written to the registrar first and thereafter to the director. First, before writing to the office and director in violation of clause 16 of the statute of the institute. Further, in your appeal to the registrar in charge, you wrote, having somehow managed to come across the BOG's minute by resolution dated item number 13. This is the minutes, my lord, which I placed annexure 2, my lord, in which, my lord, the waitlist panel was, means I shown, my lord, I placed it before your lordship at page 30. This is that minute, my lord. As per letter, you have managed to come across. Yes, but before that, man, what is important, man? Further, in your appeal to the registrar in charge, you wrote, having somehow managed to come across the BOG's minute by resolution number so and so. Item number 13 in the appeal to the officiating director, you have mentioned BOG's concerned minute kept as a secret document and not circulated. As per your letter, you have managed to come across the above referred confidential documents. So they did not, they themselves have mentioned, man, above referred confidential documents, man. My lord, results of the selection couldn't have been, my lord, confidential, at least to the candidates who had taken part in that particular selection. And since they didn't circulate it or uploaded it in their website, so therefore it led me to, my lord, apply for the against the subsequent advertisement, my lord, 12/12/2022, wherein I had applied, my lord. So it is an admitted fact that they didn't upload it. My lord, next page, Annexure 8. This is to show, my lord, this is a copy made from the, downloaded from the, well, this will show, this is the website, my lord. Your lordship will see there is no entry after 7/8/2021. minutes of BOG meeting has your lordship noted. In the middle. There are 3 entries. Last one is special joint finance committee and BOG meeting held on 7th August 2021, date 7/8/2021. Here, my lord, it is also written showing 1 to 3 of 3 entries. So till filing of this writ petition, there were only 3 entries, my lord. There were no further uploading. Man. The results were not uploaded, my lord. Nor I have also stated in my petition, it was not manually circulated. Only after taking part in the second selection, my lord, that I came to know that my name was already there in the wait list of the first advertisement. And then I filed my representations, and which they say that these are confidential information. So therefore, on the contrary, they charge me. How have you come across this? They didn't disclose it from me. They didn't disclose it, my lord. And then they say, how have you come across it, my lord? Now, my lord, again, Annexure 9 is the impugned extract of the board resolution, page 50, my lord.
This is also impugned.
This is also impugned, my lord. Actually, what happened, my lord? When we filed the first writ petition, my lord, this was not there. During the pendency of the first writ petition, my lord, they resorted to this. Then we came with the, my lord, the second, my lord, comprehensive writ petition. That is why, my lord, I am placing the submission in the second. Now, your lordship will see. At page 50, my lord, the following candidates appeared in the interview. Names are given. Opurbo Bhuya, Himadi Rajbangshi, Kumud Chandra Das, Lankeshwar Boro, Manu Jyoti Pathak, Manasi Nayak, Narayan Kolita, Surendra Mohan Khaloi. So the petitioner's name at the end, my lord. Although I was the second senior most in the cadre of the senior superintendent, my lord.
Yeah, serial number 8.
Serial number 8 is the petitioner. Then, my lord, page 51. The board was requested to consider the recommendation of selection committee as above for appointment to the post of assistant registrar. And then the board resolved as below, resolved that the recommendation of the selection committee for appointment to the post of assistant registrar be approved as below. Manoj Jyoti Pathak. He is respond number 7. General category, unreserved, as per rule, man. Now, your lordship will kindly see how the second post occurred, my lord, during the same vacancy here. That is at Annexure 10, page 52. There are altogether 16 posts in the cadre. Both, my lord, internal promotion as also direct recruitment. 16. The initial advertisement was when there was the ratio was divided in 75%, 25%. 75% for direct recruits. So there, my lord, candidates are more, my lord, for direct recruitment, and the lesser opportunity for the internal assessment. Then, my lord, page 53, your lordship will see. Again, serial 03, my lord. I think it is marked also. Right hand side column. In terms of the MHRD letter number so and so dated 2/11/2017. The committee recommended to earmark 50% of the posts of assistant registrar are to be filled up by promotion. This was of June. 17th day of June, my lord. These minutes. Page 52. 17th day of June, my lord. So, from then onward, my lord, it became 50 is to 50. So, out of 16 posts, 8 posts on this side for internal promotion and 8 posts for direct recruitment. Now, Following this
So
change,
this 50 became applicable with effect from 17 June.
yes, my lord. 17 June, man. The second subsequent advertisement was of December, man.
Mm.
Now, because of this, my lord, that subsequent vacancy arose, which was on the part of the direct recruitment, that came over to the for internal promotion, my lord. Otherwise, it wouldn't have come, my lord. At least during that year, my lord. Since they had approved this rule, my lord, this amendment was brought about. So therefore, that post, my lord, arose for internal promotion, my lord. And that was their advertisement. Although this had happened in June, my lord, and they advertised in December, my lord. My lord, if that advertisement had come sometime in January, my lord, or after the validity of the panel list, the petitioner definitely wouldn't have any case, my lord. But since that vacancy occurred during that vacancy year, and the advertisement, it was notified on 12/12/22, my lord. So therefore, he definitely has a case as per these guidelines, man. Now, your lordship will kindly see page 60, when we the first writ petition, my lord, WPC 3423. It is, my lord, this order was passed on 14/6/23, my lord. A direction was given to the respondents to file their preliminary affidavit. Preliminary affidavit on behalf of the IITZ, that is IIT Guwahati, we positively file on or before so instrument. And they file a preliminary affidavit, my lord. In that case. In the earlier case, my lord. I have to place it because what they have stated there, my lord. My lord, that your lordship will definitely find in the other writ petition, my lord. This preliminary, just for a while, I will just.
Preliminary affidavit.
Yes, my lord. Dated, my lord, 26/2023. In the the earlier writ petition, my lord. Now, they have denied my allegation or statements, my lord, and then in page 62, they made a place a contention, my lord, their contention. Why, my lord, that also I will show, man. At page 62C, subsequently, the Board of Governors, IIT Guwahati, in its 111th meeting held on 17/6/22, my lord, the minutes I have just placed, my lord, if your lordship, has sanctioned, your lordship will kindly mark this word, sanctioned by a new post of assistant registrar to be filled up by the internal candidates. Now we understand when, my lord, the word sanction connotes great relevance, my lord. It has to be sanctioned from the government, from the ministry it comes, my lord, in the response. It is an absolutely new thing, man. But here in this case, it could not have been, my lord, sanctioned because it was an existing same, the number of vacancies remained the same, 16 as before this amendment was brought about, and also after the amendment. The total number of, my lord, the vacancies in that cadre, my lord, remain the same. And this is why, my lord, the court on an earlier occasion also directed them to produce the records, because this is the ground they have taken. Because if they can show that it is a newly sanctioned post, then, my lord, that earlier binding will not come. I'll just take your lordship. My lord, that annexer one of that new petition, that the second petition, my lord. Just for a minute, my lord. Page 27, the first annexer. Why they are taking this contention, making this contention?
Yes.
Annexer one at page 27. Your lordship will see at the bottom, general information, cut-off date for counting, etc. Reservation will be applied wherever applicable as per drawn roster. Then, my lord, 3. The panel selection stroke waiting list drawn up by Departmental Promotion Committee as per Government of India norms would be valid for 1 year. So they have accepted that the wait list was valid for 1 year. If any post falls vacant within 1 year of the DPC meeting, the same will be filled using the waiting list as per category. This is very specific. So the petitioner ought to have, my lord, been inducted, my lord, when the subsequent vacancy arose, instead of going for, my lord, a fresh advert. Now, next line, your lordship will kindly see. This will not apply for fresh sanction of post. This is the reason why they say that this was a fresh sanction. Now, my lord, we all understand what is a sanction, and this is, my lord, due to the redistribution that your lordship will examine from the records, which they will place at your disposal. They had earlier brought the records with them, but today
You
the
have to record.
Record.
Records are the.
Yeah.
this will not apply for fresh sanction of post made after the advertisement. Candidates will select as per recommended list. So that is the case, my lord. Now, in this, after this, my lord, that second petition was filed, my lord. This remained like that, but the honorable court, my lord, kept the earlier petition also alive. So second writ petition was, and they are also, they filed affidavit, my lord. They, my lord, took the same stand, my lord, in that, but they have added something else, my lord. I will also place that. This is dated, my lord, 25/9/2023 in the writ petition 3937 of 2023. We have replied to their affidavit, man. Page 64, your lordship will kindly.
64.
Yes, ma'am. Your lordship will see the page 64, the above advertisement circular contains certain conditions. My lord, the same condition, my lord.
1 minute.
Yeah.
64 something is here.
My lord, that is the affidavit, my lord, in opposition by respondent number 2 to 6. We received it on 25/9.
It says in affidavit filed on behalf of writ petitioner in respect of executing personal service and respond number 7.
Your lordship will kindly take up the affidavit in opposition, my lord, filed by respondent 2 to 6.
2 to 6.
6. The IIT
Yes,
one.
yes. Page 69.
Page 64, my lord, my printed, that internal pagination, man. Page 64.
69.
62. It is given by name, my lord. Para 3, my lord. Para 3. Your lordship, para 3, subclause 1, then subclause 2. Your lordship will kindly come to subclause 2. There they have quoted that rule, my lord. The panel, again, my lord, reading out. Selection stroke waiting list drawn up by Departmental Promotion Committee, DPC, as per Government of India norms, would be valid for 1 year. If any post falls vacant within 1 year of DPC meeting, the same will be filled using the waiting list as per category. This will not apply for fresh sanction of post made after advertisement. So again, my lord, same stand they have taken. In addition, my lord, what they have done, Now, my lord, they, your lordship will kindly see. Page, next page, man. The clause 3 of the general information, subclause 3 of the advertisement circular dated 5/1/22 therefore lays down that the right of the candidate of the waiting list to be appointed is limited to the already existing promotional post. They are saying it's a newly sanctioned post that your lordship will find from records. So is limited to the already, if it is already existing, then my lord, my right survives. With all eligibility criteria and all assessment metrics falls vacant. Now they have added this additional, they have improved their stand. Now they say that that initial my lord selection was with all eligibility criteria and all assessment metrics. But the guideline says that during the vacancy year, these metrics, assessment metrics remain the same. My lord. I had read it and I will read it out once again, my lord. That is the reason why, my lord, fresh selection is not necessary. Instead, the candidate may be drawn from the wait list. Only if it is not a newly sanctioned post. If it is a newly sanctioned post, then obviously I have no case. So this is the additional ground they have taken, which I have denied mine. Because, and this time also I was not disqualified. Assuming they have brought in new, I was called for interview. So therefore, I qualified so far as the assessment metrics are concerned. And the rule, my lord, clearly says my lord, I'll just place it. I'd like to take your lordships once more, my lord, to page 11 of my writ petition, my lord. Page 12, my lord, it will be. I am quoting from clause 449, page 11, page 12, which says, my lord, officers who have already been empaneled or placed in the extended panel but could not be promoted due to these vacancies not actually becoming available need not be reassessed by supplementary DPC as assessment metrics remain the same. They cannot change it during that year. This is very clear. They want to improve their standard, not only that the newly sanctioned post, the assessment metrics have also been, my lord, other than what it used to be before. They are vague, but then they want to say that. That is the improvement they want to do. But even then, I was called for the interview in the second. So qualification, my assessment metrics, I think this will not be relevant for this purpose. And they cannot change it, my lord. That is why I am placing this rule. It remains the same during that vacancy. Till 31st December of any year, my lord, that will remain the same. If you have made a wait list, you'll induct someone from there. My lord, obviously from the top, my lord.
Yes.
Other things, my lord, I have denied, my lord. I have categorically denied their stand in that. And so far as the private respondent is concerned, my lord, they want to say that I have taken participation, I have participated in the second selection, my lord. Then having come to know that I was not selected, so therefore, my lord, that is the rule, my lord, that is the Jammu and Kashmir and Sanana and all that. That one who has participated in the, my lord, that is not my case, my lord. I am not challenging the selection on that ground, my lord, that I was, or otherwise, my lord. My lord, the admitted case is that, my lord, my selection in the earlier selection, the result in the earlier selection was not made known. It was neither uploaded or nor manually circulated, my lord. I was not aware, my lord. Otherwise, my lord, I would be a fool, my lord, if I may so say so, to participate in that. Because the guidelines say that if the wait list is there and during that vacancy year you are making you're filling up a subsequent post by internal promotion, then my lord, obviously you'll pick someone from that. And they say that this was kept confidential. How have you come across this? How could you learn of this? That's what they say, my lord, in reply to my representation.
What is your answer to that?
My lord, I have come to know, my lord, this is, I have not unearthed something very secret, or it is that, my lord, concerns me, my lord. I took part in that selection, my lord. I am working, my lord. I am a working person from there. Somebody told me, whatever. But it is not that, my lord, some confidential secret or something which is not made public under the RPI Act that I have unearthed and made public. It is not so. It is the minute of selection of the first selection, which shows that my name figures at the top of the wait list.
Yes.
And that, my lord, I will also I'll once again place it before your lordship where they had admitted. Page 48, my lord.
Page
48, Annexure 7. Bottom, my lord. The last paragraph. This was with reference to my letter or my representation. So they say, as per your letter, you have managed to come across the above referred confidential documents. They say confidential documents. Therefore, the undersigned, I am sought to be penalized, my lord, for placing that the fact that I was selected at the top of the wait list. They now want to penalize me. They have kept it secret. Therefore, the undersigned is directed to seek the complete details from you, how you may have managed to get the confidential part of the BOC's minutes. You are therefore asked to submit the complete details regarding the same within 3 days from the receipt of this letter. My lord, I am a serving officer there. I am already working there. And information of this sort falling in my ear or coming to my notice cannot be something, my lord, out of the world. And it concerned me, my lord, my result, I took part in that. I have not, my lord, disclosed something relating to the others. And can it be, my lord, that they will hold a selection and they will not publish the results, my lord? Unnecessarily, I had gone for the second, my lord, selection. What is there for me? Why would I come for the selection?
Yes.
That is my submission, my lord. My senior friend and my friend, Mr. Mahanta, would like to reply. And if necessary, man, as a reply. That is the issue, man. And your lordship has to see, but whether is a post falling vacant because of the redistribution of 50%, 50%, or as the June 2022 minutes would show, which I have an, or it was a newly sanctioned post from the ministry. It has to come from the ministry. That much. If it is a newly sanctioned post, my lord, then they have a case, man. But if it is not, then my lord, surely the petitioner deserves to be in that post.
Make with your lordship. At the beginning, I have to clarify that the DOPT what they stated is not applicable to us, Lordship. Lordship may kindly peruse. Para 10 of our counter affidavit.
10.
Yeah, 10, Lordship. Page 76.
1 minute. Yes.
Dear Lordship. The petition relying on DOPT's guidelines. In that we say the statements made in para 7.
Something is wrong. Paging is wrong.
The internal paging 76. Lordship. If you internally. Para 10 of our counter affidavit, Lordship. we can.
Para 10.
Lordship.
Page 83.
Yeah, Lordship. Something. Huh? Maybe. Lordship, kindly say, I read out. Statements made in para 7 and 8 of the writ petition. Lordship, is it correct?
Yes.
Are devoid of any basis as well as misleading. In this regard, deponent begs to state that IIT Guwahati being an autonomous institute, the DOPT guidelines are not directly applicable for the institute. The institute follows recruitment rules approved by the BOT. So DOT is not directly applicable to us. Whatever may be there, some guidelines may be favoring the petitioner, but we are not following them. We have their own rules. That I clarify before I start my argument, Lord.
You have your own rules.
Yes, Lord.
Where are the rules?
Rules I have, once I place it before that, another copy there. It may be in the Lordship's report also.
Rules.
Lordship. This is like this, Lordship. We have compiled with all the decisions of the BOG and made the.
No.
Lordship. Then I'll list it out.
You have an extra copy.
Yeah, now this is my copy, Lordship, but only for this page it will be there. Lordship, we paid with this. No, it's in it.
Why can't you make an extra copy and come?
Lordship.
It is difficult to read, hand it over.
Or, no, that one copy I have placed before this one.
No, no, it's not here.
The first hearing. Lordship, just I read out a line, Lordship. May I read out, Lordship?
Yes.
The defense PA, name of the post assistant register. Now, serial number
No,
9.
no, the senior counsel.
Lordship.
I need to have a copy so we can synchronize together.
I'll provide a copy, Lordship. By 2 AM, I do it on the department computer. At 2 PM, we shall provide a copy, Lordship. Today.
2 PM, there will be some difficulty today. You have the records also?
Records also at 2 PM. He somehow missed out the records at my chamber. He's bringing it to
No, no, today 2 PM, there will be some problem.
the records also he will place at 2 PM. And this copy.
Then let us take up on Thursday.
But in that case, it has to be part of it.
Yeah, yeah. perfect.
Let me pass. Yes.
Thursday, like, one day ago.
Otherwise, it's difficult, no, ending over reading. Let
yeah.
us have everything at
Exactly.
properly, and in the meantime, you take the correction of this, of your
That,
paging.
yeah,
Paging
yes,
is-
my lord.
15 period.
17, madam.
17 days, 7 days.
Is working in our.
Yeah,
This one.
This week it is working.
there's no problem. We can take up on 17.
And I am so.
Yeah, make.
It will be easier.
Yes.
Already on the 15, how many feet on me, pilot there will be problem. I got Friday or Saturday.
My lord, let it be taken up on 20th in that case, my lord. It will be a Tuesday hearing day matter. It's a part-heard matter.
No.
Why should it come in the
Yeah.
miscellaneous?
Let it come on 28, Lord. In that
Any
case.
problem?
No problem, no, 28, no problem.
20th will be, if I understand,
It's a
Tuesday,
hearing
man.
date, Lordship.
Tuesday, man,
Okay.
on 20th.
Heard Mr. B.G. Goswami, learned counsel for the petitioner. Also heard Mr.
R.P. Kapati.
R. Kakuti, learned senior counsel. Assisted by Mr.
S. Sutadhar, Lordship.
S. Sutradhar for the respondents, 2 to 5.
Lordship.
In
Oh, no,
first case,
no.
2 to 5, Lordship.
Second case.
Second case, 2 to 6.
2 to 6.
2 to 6.
And Mr. No, on top you put MS Agyan, then it's CGC for the responding one. Then after that you come so and so on. And Mr. TJ Mahanda, then a senior counsel assisted by MS P. Bhattacharya for the respond number 7. I think
No, not 4. Item 2 and 3.
Sorry,
He couldn't-
you are appearing or Gyan is appearing?
in 3, he is getting 2
13 part. List for 40 hearing on 20.
20th, man. Well, only one year lordship may not, they will place the records.
Yep, on that they please bring
Mr. Record dates,
bring an extra copy of the rules
is Lordship, I'll place it.
and the records.
Lordship.
My lord, records may be, my lord, your lordship will kindly mention it because it has been happening when they say records are with them at the end of the.
No,
Okay,
that,
man.
it sometimes happens, this is not motivated
Please.
submission, Lordship.
That's the
I'm
senior
not
counsel
saying
I
it's
said,
motivated.
yeah, that is not
For the
a submission to be made.
respondents,
Yes.
2 to
I
6
said, place the record, place the record.
shall produce the records.
Yes. Much
On the
better.
next written.
Oblige.
Item 4 for orders.
May it please your lordship. My lord, this IA is for they have.
Before my learned friend begins, my lord, we have received the extra copies of the IA only tomorrow, yesterday. So. we
How can
need
that
some
be, my lord?
instructions.
How can that be? Every time they are coming up with this kind of submissions, I don't know what they are having. On 8/2/2004, we have given them copies. Again, yesterday also we gave them copies. So they're getting copies, and again on time and time they have been submitting this, my lord. My lord, may see this, my lord. This is, there has to some kind of stoppage in this, my lord. My lord, every time they're doing this, my lord.
Lordship has short accommodation, Lord.
My lord, despite of the fact that I'm having an interim order, they are coming up with government had been asked to produce the records. They have not producing the records. Last time they said they did not get the copy. On 8/2/2004, I have given a copy. On 12/2, again, I have given a copy. As per my lord's order, I gave it the copy the next date itself. What kind of submission my friend is he making here, my lord?
You can give it back.
My lord,
You've got the copies, isn't there?
Lordship, only the extra copies were served to us yesterday. So we need some instruction, Lordship. In the gradation list, they have raised certain objections. For that, we have to take the instruction from the
So when do you want?
Lordship.
My lord.
Anyway, in the next week.
my lord, by the next week, the month of providing the gradation list will be over. A 1 month duration will be over. My lord, may just look into my matter once, my lord, because every time there's just some kind of not receiving the copy, some of the excuse for the government.
That part I'm
Yes.
clear now.
Yes.
I'm clear now. They've received the extra copies.
My
They
lord,
want some instruction. They want a short date. We'll fix it on Monday or Tuesday.
my lord, on Thursday, my lord. On Thursday, my lord.
Thursday, will it be possible for you?
No, my lord, it will be difficult. My
So,
lord,
my lord,
we
at
have
least till the next
tomorrow is
return,
the holiday.
at least till the next date, my lord. They should not finalize this provisional list, my lord. Because I have an interim order in the main writ petition, my lord. The respondent number 5 does not have a promotional order, not having a DPC. Nothing has been conducted, my lord. And the court has time and time I have stated.
But Mr. SP Sharma and counsel for the applicants. On request made by Mr.
U. Sharma on behalf of Mr. K. Kaur, additional advocate general.
U. Sharma, Leonard counsel appearing on behalf of K. Conway, Leonard additional AG. List when?
Lordship, on 22nd. Is that okay?
That is too long.
Then, my lord, on 21st.
Yeah, 21st.
My lord, on 20th, it's a Tuesday, hearing day, my lord, at least.
21st also. We
No,
can
my lord,
take
it's a
up-
Wednesday, my lord, 20th, my lord, so orders it will come, so my lord have lots of matters would be there on, my lord, on 20th.
I'll leave it to your okay.
20?
20.
20.
Will you oblige?
My lord, at least till the next returnable date, because they
No,
were
no,
final.
we'll see. There's a
My
few
lord,
days.
they may come with some, because they have not, there's a willful violation, my lord. At least protecting it till 20th, my lord.
We'll see. Next day.
Item 5 for hearing.
May it please your lordship.
1 minute. Yes.
Well, I'll keep it as short as possible. Lordship has heard the matter earlier.
No, no, it was heard on October. So
I'll
you
refresh, my lord.
you proceed properly.
My lord, I joined as an assistant teacher in Government High School, Kohima, sometime in October 1967. Thereafter, through proper channel, I joined REC Silchar. In my list of dates, if lordship takes up for a moment, my lord, the list of dates in the writ petition, I would go by that. That would be easier.
List of dates.
List of dates.
1
After the synopsis.
Yes.
Well, 3/10/1967, I joined as an assistant teacher in a government high school, Kohima. Now, on 6/4/1984, I joined Regional Engineering College, Silchar, then as it was named, REC Silchar. Now, here, I left Kohima and I came to Assam, Silchar. 31/3/1988, Government of Nagaland granted voluntary retirement to the petitioner on completion of 20 years of service. So this was Nagaland government. And lordship may come to 31/12/2004. I retired from NIT Silchar. These are the 4 relevant dates. I was in Kohima in a school. Thereafter, I joined REC Silchar. I was granted voluntary retirement by Nagaland, Government of Nagaland. And here I retired on 31/12/2004.
You joined REC Silchar as what?
Lecturer, Department of Humanities and Social Sciences.
1 minute. Lecturer?
In the Department of Humanities and Social Sciences.
Yes.
On 31/12/2004, while I retired on attaining the age of superannuation, I was holding the post of lecturer and head of the department of same department, Humanities and Social Sciences. I was the HOD then, in the same department.
Retired as?
Lecturer and head of department of Department of Humanities and Social Sciences.
Yes.
But while I had moved from Nagaland to REC Silchar, at that point of time, the government of Nagaland had given me lien leave. My substantive post at Nagaland, I came to Assam in Silchar. So I was under lien leave. And considering that a period of 3 years, 11 months, and 25 days, I've pleaded at paragraph 4, page 4. My voluntary retirement was calculated and computed. Then onwards, I continued in REC Silchar. Subsequently, it was named as NIT Silchar, and I retired on 31/12/2004. Now, all throughout, if Lordship takes my prayer, it's over the prayer at page 10.
No, no. When you joined as lecturer, assistant teacher in the government high school,
Nagaland,
Nagaland,
Lordship,
then you joined as lecturer in 1984.
Lordship,
Correct.
in
That-
Silchar.
In Silchar.
Silchar.
That time you were having two posts.
No, I left Nagaland
Hmm.
through proper channel. I joined here. I was not confirmed by them yet, so I was on lien leave.
Lien leave.
Lien leave from the state of Nagaland.
It was granted to you.
Yes, yes, yes.
Where is
This-
that document?
The document is not disputed fact, Madam. On this fact, we are not disputing, both of us. Because I was granted voluntary retirement also by the state of Nagaland. Now, their action was, after I was granted voluntary retirement from the state of Nagaland, they did not pay me the pension which I was receiving from the government of Nagaland. They deducted that amount from my salary in Silchar. REC Silchar, whatever salary I got, they deducted the pension from Nagaland. Eventually, when I retired, I was not given pension by them on the count that I was having two pensions. They took a plea that I was having two pensions, which is not permissible under the CCS pension rules, Rule 7(2). This is their case of rejection.
Give me this CCS page.
Mr. Bujani. If Lordship takes up page 15 of the writ petition for a moment, 1.5, their wording is there.
Page?
1.5 of the writ petition.
Yes.
May I read it?
Mm.
Madam, with reference to your option received at this end on 15th of March 2013 regarding switching over to pension scheme as per so-and-so, dated 11/2/13, it is informed that your option cannot be accepted on the following grounds. Number 1, you joined this institute on 6th of April 1984 and served for 20 years, 8 months, 25 days up to 31st of December 2004. In terms of CCS Pension Rule 72, you're normally entitled to get pensionary benefit for the service rendered at this end. But from the records available at this end, it is seen that you were granted voluntary retirement by the government of Nagaland for your service in the government high school Kohima on completion of 20 years service calculated up to 31/3/1988, which included period of service rendered in an institute with effect from 6/4/1984 to 31/3/1988, that is 3 years, 11 months, and 25 days. As you were granted the benefit of voluntary retirement, retiring pension by government of Nagaland and subsequently re-employed in REC Silchar, presently NIT Silchar, you are not entitled to get second pension from this institute by Rule 7(2) of the CCS Pension Rules 1972. That's all. This is their stand. I would not dispute on the correctness of the facts and the dates, while the way they understand and tend to explore Rule 7(2) to deny my legitimate pension is a subject matter for consideration before your Lordship. May I invite my Lord's attention to Rule 7(2) of the CCS Pension Rules.
Yes.
7. Limitation on number of pensions. A government servant shall not earn two pensions in the same service or post at the same time or by the same continuous service. 7.1 is not applicable. 7.2. Except as provided in Rule 19, that's military pension, we skip that. A government servant who, having retired on a superannuation pension or retiring pension, is subsequently re-employed shall not be entitled to a separate pension or gratuity for the period of his re-employment. To appreciate the contention, may I break up the phrases and the relevant words, the preconditions attached to attract this provision of 7.2. I read once again with my Lord permission. Except as provided in Rule 19, a government servant who, having retired on a superannuation pension or retiring pension, I pause for a moment. The precondition is either superannuation pension or retiring pension. My Lord would have the superannuation pension, my Lord, at Rule 35.
Yes.
May I read? A superannuation pension shall be granted to a government servant who is retired on his attaining the age of compulsory retirement. Now, compulsory retirement, Rule 40.
Yes.
May I read? The pension I get in compulsory retirement is 40. A government servant compulsorily retired from service as a penalty may be granted by the authority competent to impose such penalty, pension or gratuity or both at a rate not less than 2/3 and not more than full compensation pension or gratuity or both admissible to him on the date of his compulsory retirement. My Lordship, penalty. This would attract a penalty. This is not my case. Would I be able to persuade my Lordship what I'm actually trying to? Now, the other precondition is retiring pension under 7.2. 7.2 to be applicable, it has either to be a superannuation pension or a retiring pension. Retiring pension, my Lord finds at Rule 36.
Yes.
May I read, my Lord? A retiring pension shall be granted A, to a government servant who retires or is retired in advance of the age of compulsory retirement in accordance with the provisions of Rule 48 or 48A or of these rules or 56 of the fundamental rules or Article 459 of the Civil Service Regulations. Meaning thereby, I do not touch 60. I am retired prior to 60 at my option. So 36A is not applicable. I'll go to Rule 48 and 48A in my subsequent stages. B, to a government servant who, on being declared surplus, opts for voluntary retirement in accordance with the provisions of Rule 59 of these rules. So 36A and 36B, either or, neither nor, is not applicable to me. So retiring pension would not be applicable to me. However, since the Rule 48 and 48A has been indicated as a precondition to exercise of 36A, may I invite my Lord's attention to 48A. 48 and 48A.
Yes.
At any time after a government servant has completed 30 years qualifying service, he may retire from service, or he may be required by the appointing authority to retire in the public interest. And in the case of such retirement, the government servant shall be entitled to a retiring pension. Provided that a government servant shall give a notice in writing to the appointing authority at least 3 months before the date on which he wishes to retire. Meaning thereby, it's a voluntary act on my part and has nothing to do with me sailing through and reaching the age of superannuation. Of course, it must be prior to that, but it's a voluntary act on my part. B, the appointing authority may also give notice in writing to a government servant at least 3 months before the date on which he is required to retire in the public interest, or 3 months pay and allowances in lieu of such notice. If they initiate, that's the rule. Provision. Provided that where the government servant giving notice under clause A of the preceding proviso is under suspension, it shall be open to the appointing authority to withhold permission to such government servant to retire under these rules. Meaning thereby, if I'm under the eclipse of shadow of suspension, then I may not wriggle out by way of 48A to have a voluntary retirement below. Provided that further the provisions of clause A of this sub-rule shall not apply to a government servant, including a scientist or technical expert who is on assignments under the Indian Technical or Economic Cooperation program of the Ministry of External Affairs and other aid programs. B, 2, posted abroad in foreign-based offices of the ministries or departments. 3, on a specific contract assignment to a foreign government, unless after having been transferred to India, he has resumed the charge of the post in India and has served for a period not less than 1 year. Does not attract me either. 1A, a government servant referred into clause A of the first proviso of sub-rule 1 may make a request in writing to the appointing authority to accept notice of less than 3 months, giving reasons therefore. Not at all. On receipt of such a request, I skip that because I have not even put a request for that. 2, a government servant who has elected to retire under this rule and has given necessary intimation to the effect to the appointing authority shall be precluded from withdrawing his election subsequently, except with specific approval of such authority. This is on the doctrine of locus penitentia. Suppose I tender my resignation or I tender my application for voluntary retirement. So before the authority accepts or approves that, I have a fictitious timeline to withdraw. This is a bar on that. So it is not even affecting me. 3, for the purpose of this rule, the expression appointing authority shall mean the authority which is competent to make the appointments to the service of post to which the government shall retire. Well, that 48 in toto is not applicable. Now 48A. At any time after the government servant has completed 20 years qualifying service, he may give by notice of not less than 3 months in writing to the appointing authority to retire from service. I have not given him notice to retire from service on completion of 20 years of service. But 48A, if Lordship skips for a moment and goes to rule 6, sub-rule 6, 48 is 6. This rule shall not apply to a government servant who A, retires under Rule 29 or B, retires from government service for being absorbed permanently in an autonomous body or a public sector undertaking to which he is on deputation at the time of seeking voluntary retirement. Although in the state of Nagaland, I seek voluntary service, albeit I am not on deputation in REC. So basically, none of the rules which require to be fulfilled, none of the conditions which require to be fulfilled under 7.2. May I read 7.2 for a moment? Now it will be easier.
Rule 7.2.
7.2, the very genesis of them, the sheet anchor on which they refused my prayer for pension.
Yes.
Except as provided in Rule 19, a government servant who, having retired on a superannuation pension or retiring pension, these two are absent middle, is subsequently re-employed. Now, before going to the part of re-employment, they treat me as a re-employed person. But prior to that, this must be satisfied. In the event they treat me as a re-employed person, I'm thinking aloud, there must be on record a reappointment letter. So reappointment comes in. If I go to Rule 18, how the concept of re-employment comes in, Rule 18. Because re-employment has to be read in context with 7.1. May I read how the concept comes in? Counting of pre-retirement civil service in the case of re-employed government servants. This is I'm borrowing the concept. A government servant who, having retired on compensation pension or invalid pension or compensation gratuity or invalid gratuity, is re-employed and appointed substantively to a service or post to which these rules apply, may exercise option either to continue to draw the pension or retain the gratuity sanction from his early service, in which case his former service shall not be counted as qualifying service. B, cease to draw his pension and refund the pension already drawn. These things apply. My lord, here is a case of two separate compartments, two separate states in India. In Nagaland, while I was there, I served through proper channel. I came here, and we are on one page to say that there is no dispute in the manner and method in which I moved in service. They also admit and adhere to the fact that I was on lien leave from the government of Nagaland while temporarily being posted in RSC Silchar. Thereafter, counting 3 years, 11 months, 25 days, my voluntary retirement was given by the government of Nagaland. Consequently, pension started flowing. This pension was withheld by them since then until my retirement. And on the date of my retirement, till date, as I'm arguing, my lord, they have not given me pension from their one, saying that it's 7.2 is applicable. I rest my case. This is my case. 7.2 is not applicable.
Let us see your appointment order.
My lord, appointment order would not be there. Its entire thing is long back issue, my lord. They will have the records. The records were called for from that. If I recall, I forgot the order date, but for the appointment order, the re-employment part, it was granted because if their affidavit is taken,
Yeah.
in their affidavit, they had made a stamp. At page 3, I just read that part. On receipt of the above intimation, BOG, Board of Governors, in its 61st meeting, under item number 9, has treated her as re-employed pensioner with effect from 1/4/1988. So they say that in some board of meeting, they treated me as re-employed pensioner. My lord, pausing for a moment. They're treating me as a re-employed pensioner in a BOG meeting does not create an estoppel against the law. I must be a re-employed person. Thereafter, their board of governor meeting. On that count, the lordship on the other side, a different bench was there, had directed them to produce the records so far as the re-employment is concerned. How I came into that, whether it's a re-employment, letter written into. I do not have a copy of that.
You don't have a copy of your
That's a
appointment order?
long way back. But they have it. They have it. That was on the other day, this was there. How do you bring in the concept of re-employment? Because voluntary retirement and pension was granted by them, you deducted it all throughout, and now once the petitioner has retired, you withhold your pension by applying 7.2. I rest my case. Address.
Here in this case, the petitioner is trying to project that he is not a re-employed pensioner. Now, if you start from the contention of the writ petition and the writ petition, here she has specifically made a mention with regard to her service condition.
1 minute.
Yes.
Yes.
Yes. Now, the petitioner joined as assistant teacher in Nagaland in the year 1967. Now, on 1984, he was selected in REC. She was selected in REC. During that period of time, 6/4/84, when she joined the REC Silchar, Then she applied before the Nagaland government. It is there in the writ petition also. When she applied before the Nagaland government for consideration of his pension, that the period of completion of 2 years, 20 years was required. Now, what has happened, if your lordship kindly see paragraph number 4 of the writ petition, where she has specifically made a mention with regard to that.
1 minute.
Yes. Page number 4 and paragraph number 4. So this will cover up the entire issue. So while joining a service under the Regional Engineering College, Silchar, the petitioner had been on lien leave as under the state of Nagaland. As on 30/3/1988, the government of Nagaland granted voluntary retirement to the petitioner for service in government high school, Kohima, on completion of 20 years of service. Threat so calculated, so calculated upon 31/3/1988. At the relevant point of time, the state of Nagaland had calculated the period of 3 years, 11 months, and 25 days. That is the period of service rendered by the petitioner at Regional Engineering College, Silchar. So that period, when she had rendered her service in the Regional Engineering College, Silchar, that was taken into consideration by the Nagaland government for calculation of his period of service, for completion of the 20 years of service, for calculating the pension. So that period is gone. Because what my learned friend is projecting, that he had joined the service in the REC Silchar prior to her retirement, that period has been taken over by the Nagaland government for computation of his 20 years of service. So this aspect of the matter was taken into account by the REC Silchar subsequently when it came to the notice of the REC Silchar. And that is the reason why we have specifically made a mention in our affidavit that has never been communicated to the REC Silchar, that the period of lien was taken over by the Nagaland government for computation of his 20 years of service. And if that be so, lordship, since whatever my learned friend is projecting in this writ petition is that her employment was prior to her retirement, this is not the case. Because 84 to 88, that particular period has been consumed by the Nagaland government for calculating her 20 years of service, the permissible limit with regard to the 20 years of service for calculation of the pension. So if that be so, if the Nagaland government has taken over that particular period when she had discharged her service in the REC Silchar, that cannot be again taken by this NIT Silchar for consideration of the fact that she is not the re-employed pensioner. Because now it is to be considered after her retirement, because that period has been taken over by the Nagaland government, that 3 years. So this is the admitted position in the writ petition. And that is the reason why, lordship, one aspect of the matter, I'm just placing the record, because I'm having the photocopy with regard to that. That has been duly communicated to the petitioner. That letter, that was on 10/11/1989. That record, the photocopy I'm having from the record, I could find out that particular communication to the petitioner. Name of the petitioner is there. Reference letter number such and such. I am referred to the above and to say that you have been granted pension at the rate of 985 and pension equivalent to gratuity at the rate of 174.07 per month with effect from 1/4/88 for undergoing voluntary retirement from your present department while joining in the service of this institution. On 6/4/84, you had retained lien against the service with the government of Nagaland as confirmed graduate teacher. But you did not inform the fact of termination of lien by your undergoing voluntary retirement from the service of the present department, that is government of Nagaland. Also, you did not inform the fact of pension granted to you by your parent department till your letter number such and such, dated such and such, addressed to the Secretary of the Government of Nagaland Education Department, copy and close to this institution. That has been communicated to the institute by the Nagaland government. She has suppressed that material information that she is getting pension from the Nagaland government, and that 3-year service has been taken over by the Nagaland government for computing the 20 years of service. That is a long back the letter was issued, that is in the year 1989, and that has not been pressed before this honorable court. Now, copy and close to this institution has been received. Written in pursuance of this letter under reference from Accounts Officer, Office of the AG Nagaland, Kohima, which was also fortunately came to your notice. On your receiving of the aforesaid pension and pension equivalent to gratuity, your pay is required to be readjusted in accordance with the government rule. So where is the illegality? Because the period of 3 years that has been taken over by the Nagaland government. So whatever service she is rendering in the institute, that is after her retirement from the Nagaland government. So it's correctly it has been mentioned as a re-employed pensioner. So this aspect of the matter has come out to light after perusal of all the records, and the BOG in our affidavit in opposition also made a mention with regard to that. The BOG has given the absolute authority to the principal to take up this particular issue. So in that view of the matter, lordship, kindly see the affidavit that has been filed by the respondent, where we have specifically mentioned or dealt with this aspect of the matter. In paragraph number 5.
Yeah, affidavit.
Affidavit in opposition.
Yes.
That with regard to the statements made in paragraph 5 of the writ petition, the answering respondent begged to state that the petitioner was appointed as lecturer in Department of Humanities and Social Science in Restwell REC Silchar and joined the said institute on 6/4/1984. And while joining the Restwell REC, she applied to her parent department for maintaining a lien on the post of teacher, selection grade in scale of such and such, still her confirmation in the REC Silchar. Her request for holding the lien in the aforesaid post was accepted subject to payment of pension and leave salary contribution. She has regularly paid the leave salary contribution and pension contributed while on lien in REC Silchar. On joining the REC Silchar, her pay was fixed and such by protecting her existing pay as teacher and granted such and such. On completion of 20 years, this is important law. On completion of 20 years service, she applied voluntary retirement from her permanent post of teacher selection grade. While calculating the qualifying service of voluntary retirement, service rendered at REC Silchar for 3 years, 11 months and 25 days was taken into account while arriving at a qualifying service of 20 years for voluntary retirement. So this is the case law. This is the absolute case of re-employed pensioner. Whatever service she has rendered in REC Silchar, that has been taken into account by the Nagaland government for calculation of his 20 years of service. So this aspect of the matter has been clarified by the petitioner in her petition. Even we have specified in our affidavit in opposition. So there is no ambiguity with regard to that. Now DCRG rupees 30,000 and intimated by accounts officer, Office of the Accountant General in Nagaland by on receipt of the above intimation. BOG in its 61st meeting under item number 9 has treated her as re-employed pensioner with effect from 1/4/88. And in pursuance to that, her pay in the post of lecturer was refixed in terms of CCS fiction rule. I'm having the BOG. In that BOG, she has been considered as the re-employed pensioner. This aspect of the matter was not being informed by the petitioner at the relevant point of time when she had applied before the Nagaland government for her voluntary retirement. That has never been communicated. Subsequently, Nagaland government communicated that thing to the REC Silchar. Then only we had issued the letter to the petitioner. She is having the specific information with regard to that. She has not disclosed that aspect of the matter before this honorable court. The 89 letter, which is very specific with regard to that. She has been specifically mentioned with regard to all the suppression with regard to the non-disclosure of the information of voluntary retirement. That has never been disclosed to the institute. And that communication was on 10/11/1989. We have specifically mentioned in our affidavit also that she was communicated. If she had communicated on 89, she had not challenged it that period of time. Now, after such a long period of time, she is coming and stating that I am not a re-employed pensioner. How it is sustainable, lordship? Because that period has been considered by the Nagaland government.
Where's the appointment order?
Yes.
And the BOG minutes?
Yes, BOG minutes. And this letter is also there. I am having the photocopy since the original was given to the petitioner. Lordship, kindly see the letter, this letter.
Oh.
ये দুটো দিও।
This is appointment order.
Yes.
In the BOG,
Yes, BOG is there.
where is it?
Yes. And the letter which I have tagged my gloss with the photocopy, this is also important, the next one. In this particular letter, the petitioner was duly communicated with regard to that aspect of the matter.
Serial number?
The last one, Lordship. The principal was given the authority to take a call with regard to that. Under item number 9.
No, there's no recording that
No, that communication was given authority to the principal, and accordingly, principal has communicated. If your lordship kindly see that aspect of the matter in the letter. And accordingly, it was.
yes. Where's the reply?
Lordship.
Where's the reply to this letter?
There are several communication. If you are in the writ petition also, they've annexed the one reply from the side of the petitioner. The lordship kindly see there on 17 December 2014, annexure 3, page number 16. If your lordship kindly see page number 16, she has admitted the respect of the matter.
Page?
Page number 16 of the writ petition.
Yes.
In paragraph number 3, therefore, I request you to grant me full pension with effect from the date of retirement, if it is granted. You can deduct the pension in a Nagaland government amount from my present pension and inform me the effective date of full pension so that I can forego Nagaland government pension in writing. Hope you will agree to that and I shall be happy to draw NITS pension and other due in it. So she has admitted that aspect of the matter and she is agreeable to that. That has been duly communicated. Apparently, lordship, this period of service, because for counting this period of 20 years, that particular service period from 84 to 88 was taken into account by the Nagaland government. If it has been taken into account by the Nagaland government, how the same can be considered by the NIT Silchar? So it has been taken by the Nagaland government for calculation of his pension of 20 years, qualifying service of 20 years. So after that period of time, she continued service in the NIT Silchar. So it's a clear case of re-employed pensioner. If it is not been taken over by the Nagaland government, then it's a different story. But here in this case,
See, the issue is, I've understood your point. So
Yes.
far, the 3 years is concerned.
exactly.
So that was taken by the government of Nagaland,
Mm.
adjusted for this voluntary term.
Voluntary term.
All right. But where's the order or that the petitioner is re-employed?
So that communication of the principal lordship,
There's no, in the communication of the principal, so there's nothing to
That-
indicate that the petitioner is appointed on re-employment.
one this communication that is of the principal, that is of 16/10/1993, that was given to the petitioner also. I'm having the photocopy. This I will place now. This particular communication in pursuance to the decision of the Board of Governors taking in its 61st meeting under item number 9 and consequent upon undergoing voluntary retirement by Dr. Mrs. Jaguma Shaikia with effect from 1/4/88 from our parent department, Education Department, Government of Nagaland, Kohima, the services of Dr. Jaguma Shaikia, lecturer is humanities of the institution, is treated as re-employed pensioner with effect from 1/4/1988. Accordingly, the pay of Jaguma Shaikia, lecturer humanities is refixed under service such and such. And copy was also given to Mrs. Jaguma Shaikia, lecturer humanities. So she is having very much information with regard to her re-employed pension. So this is, I'm having the photo.
Yes, you're employed.
And she knows it. And that has not been enclosed in the writ petition. I don't know why it has not been enclosed. Because the copy was given to the petition.
1993.
Yes, that was given to the writ petition.
You got affidavit counsel.
After finding out all the records, I could trace out this copy. Luckily, I'm having the photocopy. The institute has kept on photocopy. Otherwise, it would be difficult to establish this aspect of the matter. That was properly given to the petitioner. He knows it.
Well,
Why it
okay.
has not been mentioned in the writ petition, I don't know.
All along, the case was complicated by the other side from the institution, not my friend, from the institution, in not considering my prayer at page 16 of the writ petition. Page 17, point number 3.
Hmm.
That was the basic crux. That I request you to grant me full pension with the effective date of retirement. If it is granted, you can deduct the pension Nagaland government amount from my present pension and inform me the effective date of full pension so that I can forego Nagaland pension in writing. Hope you will agree. This is one part. I cannot retrace my steps from here. I said from the date of the retirement, Nagaland pension, whatever is there, to deduct it and give it to me. That was my stand.
No. But then this,
I'm coming to it.
this order.
I'm coming to it. It will be one pension only. In that, I'll address that also. Before that, if their stand is you cannot have Nagaland pension and NIT pension, my stand was deduct Nagaland from NIT. I'll have one pension. I'll not have two pensions.
No. How can you get a pension from NIT when you are re-employed?
Absolutely. Lordship takes my stand in my affidavit in reply, paragraph 6, page 3. The document which they had placed before your Lordship is not a part of the record, never produced till date or pleaded. I had taken a stand, categorical stand
Affidavit,
in reply.
para
6.
yes.
That we refers to the statements within paragraph 5 of the affidavit in opposition under reply. While denying the correctness of the statements which are contrary to record, I beg to state that there has been no intimation to me by the authorities of NIT Silchar during my service period or after my retirement on superannuation pension that I was officially considered by the authorities as a re-employed pensioner with effect from 1/4/88. Such a stand of the respondent authority is not correct and the same is denied. I say that such a stand of the authorities is a tactical ploy to cause prejudice to me. I say that fixation of my pay, so and so, I go on, madam. I continue to say that. I'll read. I say that I say that such a stand of the authorities is a tactical ploy to cause prejudice to me. I say that fixation of my pay by the authorities of NIT Silchar in terms of CCS fixation of pay of re-employed pensioner orders 86, as so stated in the affidavit under reply, is not legally tenable. And as such, I state that such fixation or refixation of my pay under the aforesaid orders in context is not correct and I oppose the same. I say that the action of the respondent authorities in deducting the amount of pension so regularly granted by the state of Nagaland from my monthly salary since April 98 to December 2004 is without any basis whatsoever. And in any view of the matter, I am entitled in law for a refund of the same along with interest of tune of 12% per annum. I have never been re-employed and as so projected by the authorities. I state that and there is no embargo in law in releasing pension to the petitioner which he has earned in NIT Silchar, which is independent of the pension granted by government of Nagaland. The authorities in the NIT Silchar committed twofold illegality. Firstly, most arbitrarily, illegally and discriminatorily, my pension amount so granted by the government of Nagaland was deducted every month from my salary in NIT Silchar. Secondly, post-retirement from NIT Silchar, my pension amount so receivable from the NIT Silchar has been withheld. Such twin actions of NIT Silchar is illegal and in any view of the matter. I say I have earned my pensions by way of service and the authorities are not empowered in law to withhold my pension and that too on grounds not even tenable in law. My lordship, if they come up with a document today at the stage of hearing, which is not original at all whatsoever and not even marked to me, had they come up with a document even marked to me, I have denied on record. I have denied on record.
It's marked to you.
But I have not, my lordships, they are taking a stand not by the record to say that I have to, but if it is sent to me
No, that was
Before-
not,
even
I object to
before
that
that.
lordship. On the last occasion, this honorable court has directed to produce a paper which goes to show that he is a re-employed pensioner. After a thorough searching of all the papers, we could trace out this particular document. It has been duly communicated to
My
the
lord,
petitioner.
my lordships,
He knows all these things.
what he is trying to build up the argument
No, I'm not
is
trying to
that
build up. It
they
is
have
pure
treated,
thing.
they have treated me as a re-employed petitioner.
From paragraph 4, it is clear.
Very well. In substance, we are on one page. While I disagree to the fact that I can be treated as a re-employed pensioner, they affirm and stand by the fact that they have treated me to be a re-employed pensioner. Now the test of law. In law, there is no estoppel. There's no estoppel against law. Could I have, I put the question to myself, could I have been treated as a re-employed pensioner under the extant rules in force, number one? Number two, their deduction of my pension from Nagaland until I retired from REC, that period, till 2004, I'm saying, 88 to 2004. Would that be a justifiable action in the eye of? Their entire case stands on post 2004, two pensions. Two pensions come post 2004. But the deduction of my pension from absorption in REC Silchar until my retirement, that they have not justified anyway, because that is not even covered under 7.2. He's addressing and buttressing a case of 7.2, and on touchstone of 7.2, they're not empowered to deduct my Nagaland pension, because I had not yet qualified for any pension prior to 31/12/2004. So that amount, that is an illegality apparent on the face of it, axiomatic, Miller. It needs no reference to any rule. They could not have. Now, pausing for a moment, 7.2. Unilaterally, they consider me in their fair understanding, if I may say so. It may not be a relevant consideration, but they considered me to be a re-employed pensioner. If they consider me to be a re-employed pensioner, it has to and invariably has to be within the contours of 7.1 and 7.2. Beyond that, there is no scope for consideration. 7.1 for a moment. 7.1 of the CCS pension. Their consideration has to be qua the rules, and they cannot plead estoppel against the law. 7.1.
Yes.
A government servant shall not earn two pensions in the same service or post at the same time or by the same continuous service. Neither we are talking about the same service, nor the same post, nor at the same time or by the same continuous service. If I pause for a moment, at the same time, that is relevant. The post and the service must have to be the same and at the same time. So while I was getting eligible for my Nagaland pension, the second pension was yet to be born. That came only after 31/12/2004. So therefore, Rule 7 could not have been invoked as on then. Deduction is illegal. Number two, except as, and I do not know whether I have the sanction of the advocate, the AG Nagaland for that. They must have financial sanction from the AG Nagaland for deducting my pension, that pension from my salary here. Number two, except as provided in Rule 19. So deduction is very low. Now we come. A government servant who, having retired on superannuation pension or retiring pension, is subsequently re-employed, shall not be entitled to a separate pension or gratuity for the period of his re-employment, even if Lordship holds it in affirmation in my case. Then also I am entitled to the other pension.
All. Just 5 minutes. But have you got a copy of this?
I have denied on record.
You have denied.
This was not produced. Whatever statements they have made, I've been given
You have
this.
extra copies. You have extra copies.
This is the copy from the record, lordship. I'll
Assuming, my lord, they produced the record, and knowing my friend, it would be a correct document. On the touchstone of that, whether this deduction was good in law.
No, that part I'm coming.
Absolutely.
That part
I-
I'll take
I-
it.
I-
But so far.
No,
it's
I'm not
from-
distrusting.
No, no,
Not
it's not a
distrusting.
question of distrust. That has been duly communicated to the petitioner. She
We
knows
have-
everything, and that is the reason why paragraph page 16 of the writ petition.
Fine. In 2014, by which they try to invoke 7.2. Next, to forfeit pay entire amount so deducted from the salary of the petitioner for the period April 1988 to December 2004 towards pension received from Government of Nagaland. So 88 to 2004, my pension from Nagaland which they had deducted, I'm reclaiming that. That's independent of 7.2.
Yes, Chowdhury,
Yes, Lordship.
what do you say on this?
Which one, Lordship?
Deduction of the pension from Nagaland.
No, we have specified in our this affidavit in opposition, Lordship, the relevant provision. In view of that, we are deducting that. If your Lordship kindly see. In our affidavit, page number, paragraph number 5. Paragraph number 5, we have mentioned here that she was regularly paid the leave salary contribution joining the RSC Silchar. CCS, the last paragraph, if you Lordship kindly see the last 3 lines of that particular page number 3. On receipt of the above intimation, BOG needs 65, page number 3, Lordship.
Hmm.
The last 3 lines from bottom. Last 3 lines from the bottom. On receipt of the above intimation, BOG needs 61st meeting under item number 9 has treated her as re-employed pensioner with effect from such and such. In pursuance to that, her pay in the post of lecturer were fixed in terms of CCS fixation of pay of re-employed pensioner orders 1986 in the scale of pay 2020 such and such. So that has been done in terms of CCS fixation of pay of re-employed pensioners.
Well, further down below, pay is on 1/4/1988 2,900 less pension 985 less pension equal to gratuity 174. We have to read it total.
Exactly. We are on that. We are on that.
Abruptly
No,
halting.
No, I'm not on there. I've specified the under which provision it has been done. I'm just specifying
Well,
that aspect of
they
it.
are
What my learned friend is projecting that it is not, it has been done arbitrarily or illegally. I'm saying that we have done as per the provision of the CCS fixation of pay of re-employed pensioner orders 1986.
See, in that you have said less pension of rupees 985.
95.
All right.
Hmm.
Then less pension equivalent to gratuity
174.
174.
I'm just referring to this provision of that particular.
Can you do this?
Also, kindly see fixation of pay of re-employed pensioners. Re-employed pensioners shall be allowed to draw pay only.
1 minute, let
Yes.
us get the book. 6 years pension.
CCS fixation of pay of re-employed pensioner order 1956. There.
You got the book. No, it's CCS fixation of pay. Re-employed pension. Orders 1986. This one. Where do you get this? Where do you get this?
I'm having a copy of that. I can furnish a
It's
copy.
concerns about union government. I can pass over.
Yes. The union government. Penalties are common.
2004 I can pronounce it. Report to which
Re-employed pensioners shall be this fourth. Re-employed pensioners,
You're reading from which?
this one, Lordship, this CCS fixation of pay, re-employed pensioner orders 1986.
Hmm.
This fourth. Fixation of pay of re-employed pensioners.
Yeah, I want that.
Re-employed pensioners shall be allowed
Page.
page. Lordship, this second, third page.
Fixation of pay of re-employed.
Yes, re-employed pensioners shall be allowed to draw up only in prescribed scales of pay for the post in which they are re-employed. No protection of the scales of pay for the post held by them prior to retirement shall be given. In cases, the second one, in cases where the entire pension and pensionary benefits are not ignored for pay fixation, the initial pay on re-employment shall be fixed at the same stage as the last pay drawn before retirement. If there is no such stage in the re-employed post, the pay shall be fixed at the stage below that pay, with the maximum of the pay scale in which a pensioner is re-employed is less than the last pay drawn by him before retirement. His initial pay shall be fixed at the maximum of the scale of the re-employed post. Similarly, the minimum of the scale of the pay in which a pensioner is re-employed is more than his last pay drawn by him before retirement. His initial pay shall be fixed at the minimum if the scale of pay of the re-employed post. However, in all these cases, non-ignorable part of the pension and pensioner equivalent of retirement benefit shall be reduced from the pay so fixed. So accordingly, it has been done.
The next one. The re-employed pensioner will, in addition to pay fixed under para B above, shall be permitted to draw separately any pension sanctioned to him and to retain any other form of retirement benefits.
In the cases of persons retiring before attaining the age of 50 years, 55 years, and who are re-employed, pension, including pension equivalent of gratuity and other forms of retirement benefit shall be ignored for initial pay fixation to the following extent. In
That's the
case-
fixation.
Yes.
I'm not in the fixation part. I'm in the pension part.
So you can't deduct
Can't deduct.
as per this order.
No, Lordship, this, the first one, Lordship, I'm on this, the second, in cases where the entire pension and pensioner is
Fixation.
fixation of pay of re-employed pensioners.
Yes, the fixation is different of pay.
This is a different,
Different
the
concept.
fixation of
Exactly,
this,
exactly.
But can you deduct pension? Next para.
The last pay drawn by him before retirement, his initial pay shall be fixed at the maximum of the scale of his re-employed post. Similarly, the minimum of the scale of pay in which a pensioner is re-employed is more than the last pay drawn by him before retirement. His initial pay shall be fixed at the minimum if the scale of pay of the re-employed post. However, in all the cases, non-ignorable part of the pension and pensioner equivalent to retirement benefit shall be reduced from the pay so fixed. They shall be reduced from the pay so fixed.
So we have fixation of pay.
Yes,
He's not on fixation of pay. He's on the pay scale.
Read the next
Next
para.
para.
Exactly.
The
The
re-
re-employed pensioners will be, in addition to pays fixed under para B above, shall be permitted to draw separately any pension sanctioned to him and to retain any other form of retirement
That's all.
benefit.
That's my case.
So previously his case was on.
No. I still maintain my two limbs. I'm addressing these arguments he's advancing.
Yes, Lord.
So can you deduct the pension?
So as per the first aspect of the matter, first aspect of this particular thing, of this particular provision, equivalent of retirement benefit shall be reduced from the
That
pay
is
so
over
fixed.
pay.
Yes,
Pay fixation,
Yes.
that is for pay fixation.
pay fixation.
But can you deduct the pension given to the petitioner by the Nagaland government?
No, that cannot be deducted by the
That's all.
institute. But the fact is that we have taken into account this aspect of the matter. The first one. The first one, and accordingly we have explained in our affidavit opposition also.
But he's
that the-
admitting it.
No, in our affidavit opposition also, the retirement benefit shall be reduced from the pay so fixed. So we have fixed this pay because that is the communication given to the petitioner. If your lordship kindly see that communication which was given to the petitioner. In that particular communication, it has been specifically mentioned to the petitioner.
Which communication?
Yes, I've just given the flag mark one. Lordship. The flag mark communication.
This one.
Yes. Yes, this one.
Hmm.
In that communication, that has been specifically how the things have been taken into account by the institute.
No, with regard to the deduction of the pension from the salary of the petitioner. That
Yes.
you take instructions and come back.
No, that has
Otherwise,
been,
everything is
No, no,
very
they
clear.
have admitted that part,
no,
but they are
admission.
referring to a law.
No, what we have admitted and what we are referring, this is absolutely communicated to the petitioner. That has been duly communicated to the petitioner. If your lordship kindly see the communication, I've just given the flag mark.
Where's
the other one? Only copy.
But she's 82 now.
Oh.
No. Let her get back all the pension. that you have deducted.
She's 82.
You refund all the pension that you have deducted.
With regard to deduction.
Yes.
No,
You
in the.
will have to refund it.
No, whatever she has submitted in the affidavit, this writ petition, in the writ
Are you
petition,
getting a pension
No.
scheme now?
No,
no, she has to take a call with regard to that, because in the letter that I've initially addressed before this honorable court, in 17 December 2014, she has specifically mentioned,
correct.
she has specifically mentioned the only anomaly that
Correct.
I drew the pension voluntarily, which was granted by the government of Nagaland for my previous service. I joined this NITS after qualifying the interview in the 1984 or whatever may be the thing. Therefore, request you to grant me the full pension with effect from the date of retirement. If it is granted, you can deduct the pension Nagaland government amount from
That is a different thing. That is
Yes.
a different thing.
Yes.
Supposing you pay the
Yes,
pension,
correct.
Yes.
supposing the NIT pays the pension or the REC, then you deduct the pension that-
Exactly,
because
exactly.
he or she cannot enjoy two pensions.
Exactly.
If that is held,
If
up-
that is
upheld. But he is not reading paragraph 2.
Here, I'm going against the deduction of the pension from the petitioners because petitioner is re-employed.
No, then she has to forego the Nagaland government pension. If she is getting the pension from the Nagaland government, at the
this will-
same time, she is asking for pension
No,
from
no,
the
no, he's so
institute.
correct. He is saying after 2004, forgo Nagaland pension. Then you pay me pension. What I am saying, deduct Nagaland pension from your pension, give me, if that is applicable.
No, no.
But any view of the matter, from 88 to 2004, the deduction was apparently bad in law. Paragraph 2 of that page, which is not read, page 16. He's skipping paragraphs.
Which?
Paragraph 6, page 16, paragraph 2, writ petition, my lord. He ought to have read it total.
No, that I've seen.
No, I have said it was deducted. That statement is there. Communicated to them. The only anomaly that I drew my pension voluntarily, which was granted by government of Nagaland for my previous service. I joined NITS after qualifying interview in 1984 through proper channel with leave and leave. During this leave period, I obtained required service period for voluntary retirement. With proper information to the AG Nagaland to you, I draw the pension, and at the same time, the pension amount was deducted from the total emolument of my NIT service month-wise, which is recorded till date of retirement from NITS. That was my case. And helplessly I pray, at least deduct and give me what. But now, as a lawyer, I say that part, even if we apply 7-2, all right, give me that part. That was illegal, apparently, face of it. But I'm 82, my lord. We'll not go for litigation any further. I leave it to your lordship. No further instruction is required. They justify the deduction by some way which is not even justifiable. That is, it's in a nutshell, this is the matter. Whether I'm entitled to 2 pensions or not is one thing that we leave it to your lordship to interpret and construe. But so far, deduction.
I'm clear on that.
I understand. I got it. What is
I'm clear you're not entitled
I'm not
to
sure.
2 pensions.
But the deduction.
But
would-
the first pension which was deducted from your salary
My lord.
when you were in the REC, the Nagaland pension,
That will.
that you'll have to refund.
That there's another part, my lord. If I may put it this way,
That will be fine.
there's another part to it, my lord, which they are not projecting. There are 3 stages. First, I get a voluntary, a pension from Nagaland. And Nagaland. This pension, they deduct till my retirement in REC. So this period, they will refund. All right. Now comes after retirement. I cannot get 2 pensions in way of 7-2. I must get one pension. They must pay me pension now, minus Nagaland. From 2004 onwards, they must pay me pension. They have not paid pension from
How
2004.
are you entitled to pension?
How, 2004?
I'm coming to
When
that,
you are re-employed?
my lordships.
You're re-employed.
I re-employed would not get two pensions. He would get one pension, certainly.
No.
Married 7-2 for a moment.
70, read it.
Married. Two pensions not entitled. Married, madam.
Yes.
7-2. Except as
the-
provided in Rule 19.
Hmm.
A government servant who, having retired on superannuation pension or retiring pension, is subsequently re-employed shall not be entitled to a separate pension or gratuity for the period of his re-employment. Then some pension to follow, either from Nagaland or from them.
So you're getting from
Getting from
Nagaland.
Nagaland. He's
That would
getting from
continue
Nagaland.
without any debarment.
Huh?
Ah,
No,
that's
that is the
that's-
thing. That is the thing.
I leave it to you.
You're still getting it.
Nagaland,
Yeah,
Nagaland,
Nagaland.
Nagaland.
You continue using
Continue.
it.
That's
Only thing issue is that you have to refund the pension that you have deducted. Okay,
Lordship
reserve.
may observe with regard to that, we will refund the time.
Only that part.
Yes, yes, only that part.
Okay, I'll just reserve it.
Yes,
Lordship.
Okay.
Grateful.
Uh,
Nagaland government is also there, Lordship.
oh, yes, Kichi. Anything you have to say?
Your Lordship, like it is being said, like the issue here is whether like it's with this thing, Silchar. That way, my
RV
part,
Silchar.
my government, my part, like they have done.
Yes.
You're still paying. Correct. You're still getting pension,
Getting.
isn't it?
There is a dispute with regard to that.
So after your retirement,
Lordship.
there's no deduction.
No deduction.
You're getting
The earlier one was released.
Earlier one
was
was
released.
the only
Only that.
from the day you
I-
were re-employed,
Right.
from the till your retirement, that period which they've deducted, that will have to be refunded back to you.
Only I pray, whether that document may be marked and flagged in the repetition as a part of the record.
Yes, no, I'm going to.
These some
Then I will
document.
give a
may-
photocopy with regard to that. Since I don't have any other copy, I will retain one copy. I will give a photocopy. with
You
regard
give
to
me a photocopy.
that. Yes,
of
yes, I will give a photocopy. I will give a photocopy to my
Yes, yes.
garnet friend also. For his kind perusal.
Give me photocopy.
Yes, yes, definitely.
Right
Lordship.
now. Oh, can you do it here?
We are the-
Yes.
Can you do it here? Can you do it now? Do it now. We'll do it here.
Yes.
That will be better.
I'm grateful.
for us. Heard as Bani Kulana counsel for the petition. Also heard Mr. S.P. Jautil and the counsel for the respondents to 2, 3, and 4. Correct.
Yes, Lordship.
Yes.
And Mr. and MS M. Kichi for the respondent number
एक तो लगेगा photocopy.
6.
AG, we do not-
AG, nobody appears. Nagaland. Okay,
एक तो photocopy लगेगा.
not-
respondent number 6. Hearing concluded, getting result. You put those copies.
Both. I'll take those copies, Lordship, after photocopy.
After photocopy, you take it back.
Obliged. Grateful.
All right, Lordship.
You take this book there. Get one extra here. Get one extra. Yeah, none appeals for petition. List after 2 weeks.
7.
May I please, your lordship? So the case of the petitioner here is that he was appointed as the grade 4 employee temporarily in regular scale of pay under the respondent number 2, who is director.
1 minute. Who appears for the respondent? Who are the respondents?
Respondent, Director of Health Service and
Health service. And there are some private respondents also?
yes, lordship. 5, 6.
They are served?
7. Yes, lordship. Service complete. Office note dated 29/5 of 2014 shows that they have received and court order on the last court order was on 4/1 of 2016, which states that service has been complete.
Health department. We'll fix a date then.
Okay, lordship, then
Your good name,
Friday,
please?
Friday, lordship.
Your good name?
Yunanda.
But MS Nanda, then the counsel for the petition. None appears for the respondents. Please the matter again on Friday will be difficult. We'll have it on
Tuesday, Monday or
a
Tuesday.
hearing day,
Okay, Monday or Tuesday, next Tuesday then.
22nd. That is next Thursday.
20.
20, there are many cases fixed.
Okay, let's say 27. Much obliged.
8 and 9.
May I please your lordship?
Hmm.
Lordship, my senior Mr. S.K. Mehta is out of station. Kindly matter may be passed over for the day.
Lordship, I have no objection. And Lordship, kindly fix the date.
Your good name, please?
Lordship N. Ali on behalf of R. Majumdar.
Heard Mr. N. Ali, learned counsel, appearing on behalf of Mr. R. Majumdar, learned counsel for the petitioners. On request made on behalf of Mr. S.K. Mehdi, learned CGC. When do you want?
28. Lordship.
28 is not a hearing day. 29th?
Lordship,
29.
29. R. Majumdar is not there. 29, we have some problem.
Then 5th?
Lordship,
5th March.
obliged.
Item 10.
My lordship, engage senior advocate, this is lacking some other court, is possible to matter for the time being.
The matter pertains to regular election.
I don't have any instruction for the.
May I plead your lordship. Matter relates to non-regulation of service of the petitioner lordship. The petitioner was serving as a casual employee since 1993, 94, 99 and 2021 lordship. After filing this petition lordship, they have respondents filed one affidavit stating that lordship, my case was forwarded to the government lordship, and thereafter nothing has been done. Now my learned friend has to apprise the court what is the latest position lordship.
After the judgment in passed in Upendeka, my lord, for regular.
Upenda.
Upenda.
Bill number 45,014.
Yes.
Yes.
There are 22 is a relevant part that I have.
There is no dispute about that, my lord.
But after Upendeka lordship, perhaps they have forwarded my name again, lordship, our name again, lordship. For some consideration, lordship. Upendeka judgment in the year 2017, lordship. Upenda's 2017.
Thereafter this notification came up, my lord.
This notification.
Yes. The last part, my lord, the benefits as entailed above shall be admissible on specific recommendation of the committee constituted in compliance of the Honorable High Court dated so and so, white so and so dated, and formal approval thereof by the Honorable Minister of Finance. But approval from the Finance Department is necessary, my lord. And with regard to that, the proposal has been sent.
1 minute.
My lord.
Where's the affidavit?
Lordship, affidavit, Lordship, filed by the respondent number 3 and 4, Lordship. Paragraph 4.
Yes, do you have any instructions after this?
My lord, after the notification I have placed before our lordship, the proposal for regularization or for the payment of the minimum scale, my lord, that proposal was sent to the Handloom and Textiles, that is the parent department of the Assam Khadi and Village Industries Board. Thereafter, my lord, that is required to be sent to the finance. Finance will take a call whether these persons can be regularized or their minimum scale can be given, my lord, with in consonance with the open data. That
So you have any instructions on this?
Yes, we have sent the proposal, my lord, this proposal on 30th of December 2019. So now,
After this, what happened?
after this, my lord, the finance is required to take a call.
Has the finance taken a call?
No.
Because you will be knowing it.
No, they have not, my lord, till date.
In the present case, finance is also party, Lordship.
Who is the finance department?
Okay.
Tapi, nam. Tapi menurut itu kan yang mampu nak.
Can you catch hold of finance? In catch hold of Nayak or please come down.
Petitioners' names are reflected in the proposal, manner. Now it is the finance department, we have to take a call.
It's for Nayak, it's coming.
So after judgment.
35 numbers.
35.
Here, 6 petition are there, Lordship. We are 6 petition.
Your casual workers.
Yes, Lordship, 6 petition. Serving since 2003, Lordship.
There is another finance plan. 2012, that government will regular.
Yes, Nayak. But has the handloom and textile department sent a proposal to the finance?
That after finance. If my friend confirms that it's already the finance department, then it will be easier for me to.
Have you sent it? You're the standing council
For handloom. I will appear for handloom.
you're appearing for handloom.
My
So have you sent this? Have you sent the proposal?
My lord, I have just come to know about this proposal just now. So not on record matter. I have to take certain.
Okay. You're appearing for Assam and Khati. Okay, Hurt MS
P. Bhattacharya.
P. Bhattacharya, Learned Counsel for the petition. Stop. Para. Mr.
PK Munir.
PK
Munir.
Munir, Learned Standing Council, Assam Khati and Village Industries Board. Submits that by the communication dated 30/12/2019, the Chief Executive Officer has submitted the proposal to the Commissioner and Secretary to the Government of Assam, Handloom, Textiles and Sericulture Department for regularization of services of 35 numbers of casual workers engaged in the Assam Khati and Village Industries Board. Stop. Mr. Para Ardhar, Learned Standing Council, Handloom, Textiles and Sericulture Department, prays for some time to ascertain whether the Handloom, Textiles and Sericulture Department has sent a proposal to the Finance Department. No, that's why he wants to ascertain whether they have sent the proposal.
They will have to take a decision whether they can be given a paid minimum pay scale or.
No, that is why you have heard me.
No.
He wants some time to ascertain whether they've sent any proposal. If no proposal has been sent, then he'll come back saying that no, we have not sent back. If they've sent, we'll say we have sent it by way of this communication, then you'll have to take instructions. Praise allowed. List down. When do you want?
My lord, 4th March.
Yes.
Okay.
4th of March.
Similar repetition wala by for the purpose of regulation of the pending wala can be tagged with it.
It's not regularized. It's
For-
45, it's not
Minimum
pay, not regular.
similar petition is pending wala can it be tagged with it?
Let us see what
yes.
information comes.
Yes.
I'm obliged. 11. Wait, please, Your Lordship. Lordship, I beg to apologize, but we are unable to contact the petitioner to get the latest status. So kindly pray for 3 weeks' time to get in contact with her.
Infractors matter lordship. Infractors matter lordship, no interim order was granted lordship. An advertisement was issued in 2012 lordship, an appointment was made in 2013 lordship. $11 left.
Lordship, the matter has come up after 6 years, so I kindly pray for some time to contact the client.
Okay. On request made by Mr.
A Borwa
A. Barwal and the counsel for the petitioner.
for the petition.
Is the matter after
3 weeks.
3 weeks?
Obliged.
Finish.
This petitioner,
Hmm.
he has been promoted as a sub-inspector on 30/01/2024. Lordship will find that at paragraph 5. And thereafter, Lordship, he has been transferred to Dhemaji
Hmm.
from Guwahati on 7/2. Just after joining in Dhemaji, one day later, he was again brought back to Guwahati. Now, in the meantime, what has happened here is the promoted candidates, they are sent for a training. Now, since he was neither in Dhemaji or in Guwahati, his name did not figure in the list. And the training starts today. My grievance is only that I should be allowed to go to the training. The authority may pass an order by, say, Monday, Lordship. I may be allowed to go for the training, Lordship, if there is nothing adverse against me. Others have gone, Lordship. That is my simple prayer, because
What training is it?
this is a police training, Lordship. After promotion, Lordship, they have to go through a training. And without doing the training, Lordship, they will not be eligible for further promotions. That your Lordship will
The
find,
induction course.
yes, Lordship, at Annexure D.
Hmm.
And in the next page, Lordship will find at page 26. I am at serial number 12.
Yeah.
I am at serial number 12. From ASI, now I am selected for Sub-Inspector UB. That is unarmed branch. Now, there has been some confusion maybe between the authority, because one day I was here, the next day I was not there. And for that purpose, Lordship, I have not been sent to the training. It could have been from Guwahati or it could have been from Dhemaji, Lordship. So my prayer before your Lordship at this stage would be, Lordship may be pleased to issue notice. And in the meantime, Lordship, they may take a call on sending me to the training, Lordship.
Yes, that.
My lord. Yes, my lord, without instructions, even I am unable to. Only the thing is that page 16, I can make it out that there are the departmental proceeding against him.
That was, Lordship, in the stage of ASI, Lordship.
ASI, then he got promoted.
That was dropped. That was
So my
dropped.
lord will issue notice. And
In the meantime, Lordship, they may take a call on sending me to the training.
Okay, Chaudhary, learned. You're appearing as a counsel.
Yes, sir.
Counsel.
Counsel for the petition.
Issue notice. Mr. R. Darla, the
Addition to
petitioner,
cinema.
junior company.
For all the respondents.
Interested parents on behalf of all the that's a notice on respondents account. However, extra copy. List the matter of the court. In the meantime, who is the appropriate authority? Or the concerned authorities?
Authority would be now from which district will be sent?
Now he is in Guwahati. So, Lordship, he's again back to SB. So it will be, Lordship, the Superintendent of Police SB, respondent number 4.
Are you sure?
Yes, because now he's here.
Or I'll just do the concerned
Yes,
authority.
yes. That will
In the meantime,
Respondent
the concerned authority are direct to permit the petitioner to participate in the induction course
Yes, Lordship.
for newly promoted sub-inspectors
Yes, Lordship.
within bracket UB
UP.
at LBPA, is it? Annexure D? Is this the correct one?
Yes, Lordship.
Your name is here, but
No, my name is in the list of promotion. But I am there, Lordship, but I have not been sent for training, Lordship.
what is the full term of LBPA?
L
At the Lachit Barfukan Police Academy,
Police Academy, Lordship. Dergaon.
unless there's something at first I can.
Yes. Yes.
So,
That will suffice,
that
Lordship.
will suffice?
Yes, Lordship.
I should please stop before.
I'm so sorry for troubling your Lordship at this hour.